Just days before the 2025 NASCAR season ends, a courtroom twist shocks the racing world. A judge just made a big ruling that changes how teams and NASCAR fight for control. Behind the roaring engines and cheering fans, two major teams owned by Michael Jordan and Denny Hamlin are now in a legal race that could reshape the sport forever. A sharp shift in the legal landscape for America's top-tier stock car racing. On October 28, 2025, U.S. District Judge Kenneth D. issued a summary judgment dismissing the counterclaim filed by NASCAR against 23XI Racing and Front Row Motorsports, finding that NASCAR's evidence failed to establish either an unreasonable restraint of trade or that it suffered antitrust injury. The dispute traces back to October 2024, when 23XI Racing and Front Row Motorsports filed an antitrust lawsuit against NASCAR. They alleged that NASCAR unlawfully maintained its monopoly position for offering a top-tier stock car racing series in the United States in violation of the Sherman Antitrust Act. NASCAR responded with a counterclaim in March 2025, accusing the two teams and former 23XI business manager Curtis Polk of orchestrating collective conduct to pressure NASCAR into better charter and media rights deals. Judge Bell's ruling observed that even if NASCAR experienced economic harm from the team's joint negotiations, that alone does not constitute harm to competition. Rather, NASCAR getting more or less in contract negotiations is simply that, a hit to its bottom line, not competition. The court also found that individual negotiations with each team were available and indeed took place. NASCAR acknowledged the ruling, stating, "We respect the court's decision, though we respectfully disagree with its legal reasoning. Should a resolution not be reached, we intend to appeal the decision at the appropriate time." Meanwhile, 23XI/Front Row attorney Jeffrey L. Kessler said, "Today's decision has only reaffirmed my client's unwavering pursuit of a more fair and equitable sport. The charter system at issue gives racing teams guaranteed spots in the NASCAR Cup Series and a revenue-sharing model. In September 2024, NASCAR offered a new charter agreement for the 2025-31 term. 13 of the 15 teams signed. 23XI and Front Row declined. The teams argue the charter terms waive their litigation rights and limit their autonomy. NASCAR holds that the charter system is its exclusive property and critical to its business model. Earlier this year, a separate ruling from the Fourth Circuit Court of Appeals vacated a preliminary injunction that had allowed 23XI and Front Row to maintain chartered status while the lawsuit proceeded. That decision put their future as charter teams in jeopardy. As of now, the trial on the underlying antitrust claims is scheduled to begin on December 1, 2025. Both sides remain in mediation talks. This story is still unfolding, and the next hearing could bring even bigger surprises. For full updates as they happen, follow along and stay alert for every new turn in this ongoing NASCAR showdown.